of Labor Law. He is the Emir of Employment Issues. It's Mr. Joe Sconzo.
Well, just to start, it's going to be a labor this morning doing this whole presentation, but I'm going to give it my shot. Uh, First and foremost, everybody needs to know, and if you don't know already, Florida is an at-will employment state. What that means is that an employer has the right at any given time to terminate an employee for any reason, without cause, and doesn't even have to explain it. They act, when you look at the laws and regulations, they act as if an employee has some rights, one of which is the employee can quit at any time. But the fact is that during these times, especially, how many employees are dying to quit a job knowing that they don't have anything in the wings waiting? So, that being said, what are the alternatives if you're an employee? First and foremost, it has to be a termination based upon a specific right in order for you to be able to challenge that termination. What are those specific rights? They are race, color, religion, sex, sexual orientation, pregnancy, gender, national origin, age, or disability. The key is you have to absolutely show that if you're being terminated or if you're terminating an employee, that the reasons behind it either lie because of one of those reasons, or you can explain it away. Now, performance or being, at odds with your employer, or just having an employer who's an absolute A with two S's after it, at the end of the day, that's not enough. You can't, for personality disputes, try and say there is an absolute discrimination case. Yeah, it applies to all types of jobs. And what I need to tell everybody is that here we've represented people in both the state and federal sector. We've represented doctors, nurses, even lawyers in these types of cases. It's something that it's in the perception of the person it's happening to. So, or it's in the perception of somebody who's witnessing it. So Joe Sconzo on a meeting notices that somebody's acting inappropriate towards a woman, and that woman makes a claim. Or she doesn't, and Joe makes a claim on her behalf. The fact of the matter is, there has to be that discrimination in order for it to go forward. Now, a lot of people use the terms harassment, retaliation, or even improper questions with regard to genetic information or medical information. Okay, the harassment end, which is important. Again, you have to be harassed, or an employer has to show that they didn't harass an employee based upon one of those rights. Same with retaliation. There's certain things you can do. If you, as an employer, attempt to get specific medical information, and during COVID, and I think Doug will tell you within the last week, I've had a conversation with him regarding that. COVID kind of opens up a little bit more doors to the people. So you can ask if they're getting the shot. The key to it is you're going to give the person the opportunity to have alternatives. And that's where the term accommodations comes in. So what that means is if you are requiring everyone to get a shot in your office, the way to get around having a problem if you're the employer is by offering the opportunity to get the shot or wear a mask. The person can't claim they're being discriminated against if it's for religious beliefs or some sort of other ethnic or national origin. It's entirely based upon you and the public health situation. So that gives an employer some sort of out. Basically, you always have the right to complain about that illegal treatment if you're getting it. And what happens? The first step in the process is that you look to the Equal Employment Opportunity Commission. Now, there's a setup where it's both federally as well as in the independent counties. And the numbers in your corporation, as well as the net worth or annual income of your corporation, drives where you're going to go. And when I say numbers, I mean number of employees. The process is simple, and we a lot of times encourage each individual who may have a case to do it. And that is, you basically go on their website, fill out a questionnaire. They make a determination whether they want a charge of the discrimination. And then there's a 180-day investigation. Once that investigation begins on their end, that's when an employer becomes aware of it. The fact is, even if the employer becomes aware of it, they cannot retaliate against the employee for initiating the action. So just remember that. So if you're an employer and you find out at this point that your employee has now tried to go against you and you fire them, guess what? You just opened yourself up to a retaliation claim based upon the issues that they're raising. How do you protect that as an employee? You get an employment contract, okay? Employers are very reluctant to provide that. And in providing an employment contract, they often try and sneak in the words "at will" anyway. So even if you think you're protected by an employment contract, beware, because if it says you're still an employee at will, you are definitely opening yourself up to the same conditions that exist with termination. An offer letter does not establish an employment contract. Just understand that, because that's important. We get that call all the time. Basically, what do you look for when you're doing an employment contract? Non-compete is a big issue, and people who are getting jobs often gloss over that language. A non-compete stops you from working in a particular area for a particular time period. That is important because most people close their eyes to that clause. And at the end of the day, they want to quit, they would terminate, they're terminated, and they realize, oh, for 2 years, I can't work within 60 miles of my home. There's case law out there that limits the amount of time that someone, that it's reasonable for there to be a non-compete. There's also case law that limits a geographical area. So employers try and get around that as best as they can. We draft employment agreements here, we draft severance agreements. That's important, the severance agreement as well, because you want to be able to have a package on the way out the door if you're not terminated for cause. We also handle non-payment of wages as well as non-payment of overtime cases. And that basically is under the Fair Labor Standards Act, and it relates entirely to employees making a claim that, hey, I worked 60 hours this week, I got paid for 40. We handle whistleblower actions. We're almost there, Alex. That's it? Good. We handle whistleblower action, and with my past experience in law enforcement, I also do types of cases related to criminal law and also related to police brutality and police abuse cases. So that's me, Joe Sconzo, employment law. Thank you, Alex, for waving your hand. You didn't give me my time along the way, but I tried my best.
Let's look for a Mitch Summer. Is Mitch out there?
Hello, my name is Mitch Summer. I am bald and sexy. And the name of my company is Minute Market Productions, and it's a multimedia video production company. We're based in South Florida. Our primary service is to create fresh and stylish promotional videos for small businesses. We try to keep our videos from 1 to 3 minutes because otherwise people have that glazed, bored look, and we don't want to lose their attention. Like our whether you want to display your place of business or demonstrate a service, we are fully equipped to handle your needs. We're also recording this session right now because we do many things, and Minute Market Productions is number one. Thank you.
Appreciate it, Mitch.
I
Thank
hope
you
I
so
did
much.
you proud.
Yes, he is. He's very proud.